Here is a clear and concise explanation of estoppel, its types, and estoppel of tenants under the Indian Evidence Act 1872, suitable for exams or handwritten notes. Estoppel, Indian Evidence Act 1872. Definition, Section 115 of Indian Evidence Act. Estoppel means that when a person by his words or conduct has intentionally caused or permitted another to believe something as true and to act upon that belief, he cannot later deny the truth of that thing in a legal proceeding. When one person has, by his declaration, act, or omission, intentionally caused or permitted another person to believe a thing to be true and to act upon such belief, he shall not be allowed to deny the truth of that thing in any suit or proceeding. Section 115. Essentials of estoppel. 1. A person makes a representation by words, conduct, or silence. 2. The other party relies on that representation. 3. The relying party acts to their disadvantage, for the person who made the representation cannot deny it later. Illustration. A tells B that a certain piece of land belongs to him. B buys it based on that statement. Later, A cannot claim that the land never belonged to him. Types of estoppel. Type description. 1. Estoppel by representation. When a party has made a false statement or conduct that another has relied upon. 2. Estoppel by conduct, based on actions or silence that imply consent. 3. Estoppel by record, arises from judicial decisions e res judicata. 4. Estoppel by deed, party cannot deny facts mentioned in a signed document. 5. Estoppel by election, a person cannot accept and reject the same instrument. Promissory estoppel, equitable doctrine, when one party makes a promise and the other relies on it to their detriment. 7. Estoppel of tenants and licensees, special statutory estoppel against tenants and licensees. Estoppel of tenants, Section 1 and 16 of Indian Evidence Act. A tenant or licensee cannot deny the title of the landlord or licenser at the beginning of the tenancy license during the continuance of the relationship. Key points. 1. A tenant is estopped from claiming that the landlord had no title at the time the tenancy began. 2. Applies during the continuance of the tenancy. 3. Estoppel also applies to subtenants. 4. After termination of tenancy, tenant may challenge title. Illustration, if A lets a house to B. During the tenancy, B cannot claim that A is not the owner of the property. Important case laws. Case name citation principle, Shriram Pasricha, AR 1976 SC ET 3335. Tenant cannot deny landlord's title during tenancy. MC Chakalingam v. Manjalal, AR 1969 SC 387. Estoppel operates only during the tenancy. AR 1954 358. Promissory estoppel applies even without a formal contract. Now, conclusion. Estoppel is a rule of evidence and equity, preventing dishonesty in legal proceedings. It protects trust and reliance between parties. Special estoppel applies to tenants and licensees under Section 116. They cannot deny their landlord's title during tenancy. Would you like this in a handwritten note style, flowchart, or short Q&A format for quicker revision?